Hello, and thank you for joining us for the second episode of the SLW Institute webinar series, AI-driven Innovation in Medical Technologies. Today, we are presenting on the topic of patent eligibility challenges for AI-related inventions. We will provide a detailed discussion of subject matter eligibility issues encountered in the United States and in major foreign patent jurisdictions. My name is Marvin Beekman, and I will be your moderator today. I'm a patent attorney and a principal at SLW, and my practice involves patent preparation and a prosecution for multiple technology areas, including medical devices and related software systems and electronics. Our speaker today will be Robert Hirning. Robert is a patent attorney and a principal at SLW. Robert has a technical background in computer science and software engineering. He prepares and prosecutes patents in a variety of technical areas in the computer and medical technology space, such as medical devices, medical imaging products, medical treatment systems, electronic health record systems, robotics, and a number of different applied artificial intelligence systems. We will be recording the webinar today and sending a link to the recording and slides to everyone who has registered. We will also put a link into the chat to access the presentation slides that are posted online. If you would like to ask a question, you can enter questions using the question and answer feature in the Zoom menu or in the chat. We will address the questions either during the presentation or at the end as time permits. We invite you to register for the third episode in the series, Patent Monetization for AI and MedTech Inventions, which is coming up on April 21. In the April episode, we will discuss patent sales, licensing, and general monetization strategies for patents, applicable for a variety of technologies, but with an emphasis on patents involving AI. Registration information will be sent out by email and will be available soon on our website. And with that, I'll turn things over to Robert for today's presentation on patent eligibility.
Thank you, Marv, and welcome everyone to today's webinar. Here's a brief overview of the topics that we'll be discussing today. We'll begin by discussing the patentability issues affecting MedTech AI inventions, and we'll look at some of the reasons why these applications encounter rejections, especially with subject matter eligibility. We'll compare some requirements across major patent offices, including standards applied by the US, Canada, Europe, and some Asia-Pacific patent offices. We'll also review some recent USPTO developments, including patent office guidance and major federal circuit case law decisions issued in the last few years, affecting how examiners consider subject matter eligibility. And finally, we'll finish with some practical strategies and observations for drafting and prosecuting AI-related applications. Before we begin, we'll remind everyone that today's presentation is for informational and educational purposes only, and none of the content is intended to be provided as legal advice. In particular, given the challenge in drafting and prosecuting patents in this area of technology, we suggest that you consult qualified patent counsel in the US and internationally for any specific matter. So then now let's begin by discussing some of the challenges that we see when obtaining patents on MedTech inventions involving AI. So inventions in the MedTech area can encounter a diverse mix of rejections and sometimes even more rejections than other technology areas. For instance, in the United States, Section 101 rejections can be raised for MedTech inventions where the claims refer to medical effects or observations that are characterized as abstract ideas or natural laws. And we'll dive into this issue throughout today's presentation. There's also Section 112 rejections that can be raised for written description and enablement of AI algorithms and data processing used by MedTech inventions. The rejections that are raised for AI algorithms might involve the amount and type of training data, how training occurs, how the model algorithm works, or even how results or outcome can be reproduced. There's also Section 103 obviousness rejections that are common, especially when common medical data processing actions are combined with machine learning automation. So really complicating kind of all these rejections is that when AI is involved, the patent application itself might have claims directed towards an improvement in AI to the AI model itself. Maybe the claims are directed towards an application of AI to a specific medical domain, or there's going to be some hybrid of the two.
Say, Robert, can you provide a definition of the term MedTech AI and what inventions that this term refers to?
Yeah, so when we're using the term MedTech AI today, we're generally referring to a medical device, a machine, a computer system that involves some type of AI algorithm or data processing in a medical use case. So in our previous webinar in January, we discussed a landscape of different medical technology domains that use AI, such as diagnostics, imaging, health predictive analytics, remote monitoring, personalized medicine, and other categories. So it's a pretty broad area, but the main focus here is that they're going to involve some aspect of AI and AI data processing. So at a conceptual level, MedTech inventions really can sit at the intersection of a couple competing interests. So there's an overlap of multiple types of judicial exceptions to subject matter eligibility, specifically natural laws and abstract ideas. This is because many outcomes and results of medical innovation, especially when new technology is applied, will involve some natural effect. For example, clinical correlations, detection of specific biomarkers, or the measurement of a physiological responses. And there's many other things that happen, of course, in the human body that can be measured and observed. So other times, a medtech invention might rely on how the human body responds to a stimulus or achieves a physiological change. And that itself could be viewed as the observation of a natural effect. And there's also a number of abstract computational concepts that can be found in AI data processing itself. So this might be mathematical modeling, probabilistic inference, all sorts of complex operations that happen in the machine learning models and then in the neural networks themselves. So there's really this overlap of the natural law as well as things that might be considered abstract. So another challenge is that many medtech AI systems don't operate autonomously. So medtech inventions might involve features like scoring, treatment recommendations, diagnostic predictions, and many times the implementations of these inventions will have to rely on clinical judgment or some human action to actually be used in the patient. And this is intentional for safety or oversight reasons. There's many inventions that can't just be released, of course, into the wild. There's going to be humans that are involved in the use of the invention. So because of really all these factors, a lot of examiners might perceive medtech inventions, especially data workflows and recommendation systems that use AI, as non-technical or merely mental activity or some other type of abstract idea. This is of course complicated because many aspects of medical diagnosis and treatment, especially in the US, are going to be really driven by non-technical factors such as regulatory requirements, insurance guidelines, clinical outcomes, really medicine best practices. So there's a constant tension between what's technical and non-technical in the invention and really why it matters and why the invention itself is valuable. So this doesn't mean, though, that there isn't valuable patents in this areas and that you can't obtain valuable patents. Rather, this just means that patent applicants must be very intentional about describing why an invention uses a technical means and achieves a real-world outcome, rather than just relying on an advisory or an informational result or just treating the AI as a black box.
So does MedTech AI often face a double eligibility hurdle? Medical subject matter plus AI subject matter?
Yes, there's times, especially in the United States, where we will encounter, I guess, eligibility rejections on both the medical aspects and the AI aspects. And we'll sometimes need to address sort of the natural law and the abstract idea rejection separately. However, there's oftentimes we can overcome those dual rejections with the evidence of a practical application and really a sufficient tie to technology. And that's one of the things we're going to be sort of emphasizing in the upcoming slides here is really the idea of what's technical and technological and how that really matters, especially for medtech inventions. So now let's compare some of the eligibility standards in the major global patent offices, and we'll start with the US and the USPTO here. So again, as mentioned, Section 101 is the standard being applied in the USPTO. We operate under the multi-step judicial exception framework that was explained in the Supreme Court case CLS Bank versus Alice, often referred to as Alice. The most significant precedents in this area of law in the United States were really released between 10 to 15 years ago. So while this area of law should be settled, it really does feel to practitioners like this is a constant gray area, and we're often fighting back and forth with the patent office about what is and isn't patentable. But the main concept here is at the USPTO, when the examiners pick up a new case and try to apply Section 101, they're using this flowchart that's shown on the screen here, and as the as sort of an overview of what they're actually looking at. The first aspect of the flowchart is, does it fall within a statutory category? So they're looking, is this a method? Is this a composition of matter? Is this a machine? That's usually passed very easily. The next question is the invention directed to a judicial exception? And then again, that's this idea of, is it directed to an abstract idea, a law of nature, or some natural phenomenon? And that's now we're starting to get into a question. Is something that's being run on a computer truly abstract? Is something that's being observed in a human truly a law of nature? And even if the answer to that is yes, it is directed towards a judicial exception, the question is then, does the invention integrate that exception into a practical application? And if not, even if you've answered that in the negative, does the invention add significantly more beyond the exception itself? So again, this test has been in place for over a decade, but due to the nature of the test and many subjective factors about what does it mean to be directed to an abstract idea, what does significantly more mean? There's still a lot of arguments between patent applicants and the patent office, and as well between patent owners and infringers during litigation about really what Section 101 truly does and doesn't cover. So when applying the Alice framework, especially to medtech inventions, again, there's just going to be this judicial exception hurdle for many claims because they're involving medical subject matter. So the USPTO may characterize the medical aspects of a claim as mental processes or human activity, especially if the action that's occurring is something that would be conventionally performed or considered by a doctor. Now there's also aspects of medical treatment and medical outcomes that can involve or rely on a law of nature. And there's even an entire line of case law after the Supreme Court case Mayo v. Prometheus from 2012, which provides some limitations on diagnostics and life science inventions that observe natural correlations. And again, we're trying to more focus this presentation today on the idea of computer implemented inventions, but again, some of those ideas of the laws of nature, natural correlations that can bleed over to what's being observed and what's being detected even by a computer system using AI. So, so then now if a claim does recite AI subject matter, there's the whole idea of abstract idea rejections that will really apply to medtech inventions just like they apply to software inventions. Examiners might say the use of AI in a claim is just a mathematical algorithm, a mental process, or generic data analysis. So there's really a lot of rejections that can come up in this area.
Robert, question. Why does involving clinicians or patients sometimes increase eligibility risk instead of reducing it?
Yeah, I think that's probably because human judgment and really what clinicians and what patients will do in directing or applying a medical treatment, it can often trigger this idea of a mental process that what's being done, even if it's being done in a computer, it's at its core just something that a human would do in their mind. Again, a diagnosis, they would follow a recommendation. They're coming up, making a decision based on what's around them. So all of those types of mental activities or basic human activities, they can often be boiled down as an abstract idea by a lot of patent examiners. So again, we're seeing that even to the extent that there's any improvement in an invention, often examiners will say, well, all you're doing is just improving the judicial exception. You're making the mental process better or the shortcut of the human activity better. You're not actually improving a technology or technology field. So we'll try to dive into some of those idea of what is a technology field versus a technical field a little bit later in today's presentation. So I did want to quick show some statistics about how the USPTO treats patents, especially that involve AI. The good news is that the majority of patents are ultimately allowed in the US, even when they're involving this MedTech AI subject area. So this is kind of going back to our previous presentation. We did a landscape of about 120,000 MedTech applications with a search that was performed in November. This landscape search included patents and patent applications with medical technology classifications, but that included some keyword or term in the claims title or abstract that involved AI. So again, this is medical patents involving the use of AI. So not surprisingly, what's on the screen here shows a gradual ramp up of patent application filings in this area, especially over the past 6 to 7 years. The data in 2024 and 2025 is incomplete due to publication lag times. It can take up to 18 months for new patent applications to publish. So the allowance rate and the rejection rates is now shown on the screen for this same the same set of about 120,000 patents. So the good news is that the allowance rate is roughly 72%. Again, in these technology areas that we found, this is above the USPTO average allowance rate that's a little bit closer to 60% in all technology areas. And then again, we found that out of these 120,000 patent applications, there was about 18,000, around 15%, that had some type of a Section 101 subject matter rejection. But even those cases that experienced that, again, over half have already been allowed and granted, and there's still a good number that are pending. So it's probably unlikely that Section 101 rejections can't be overcome. I guess we like to kind of characterize it as especially in the US, it's a hurdle, not a barrier that has to be overcome at the patent office. So let's take a look now at how subject matter eligibility is treated by a few different jurisdictions. So starting with Europe, which is certainly a large market for a number of medical related inventions. Europe has a different structure and approach for this topic. So what they would consider eligibility is a very easy standard to meet. Really, as long as there's any technical means, such as a computer, is enough to be eligible, you'll often see claims that will include, let's say, a preamble like a computer implemented method. Again, in this case, the tie to the computer is enough to meet eligibility. However, the real test becomes inventive step, and that becomes the challenge for the subject matter of the invention. So really, it's sort of importing some of our requirements for subject matter eligibility, considering that as part of the inventive step. So inventive step, when considered in Europe, is concepts similar to obviousness. Examiners will identify which features contribute to the technical character of the invention. So only the features which have technical character will count for inventive step over the prior art. So this means then that non-technical features like diagnostic logic or mathematical operations performed by AI, in some cases they can be ignored unless they contribute to a technical effect. So for AI-related inventions, particularly in Europe, the claim drafting must actually tie the algorithm, the AI, the medical decision, whatever's happening to the actual improvement in the technical system. And there has to be some technical effects that can be actually argued or proved. This could be increased performance, accuracy, things of that nature. So looking at a little more detail on the test here, again, applied in Europe, network that classifies some data, some medical data. Let's say it's imaging data, patient biomarkers, or something like of that nature. So in this case, the mathematical operations of the AI and how the AI algorithm works that probably would be considered non-technical, and the diagnostic conclusion that's being performed, that would also be non-technical. But if the invention, again, if it's using hardware and if it's improving processing efficiency, stability, memory usage, throughput, those are the type of aspects that the EPO examiners are looking for to be technical, to contribute to the solution of the technical problem. So really, it's a different way of a kind of approaching the problem than the USPTO does.
Um, so Robert, excuse me, do you see a strong difference in outcomes between patent applications filed in Europe and patent applications filed in the United States?
So, like our experience, at least I can say that the outcomes will be similar. Usually, you're able to get the same inventions allowed in Europe as you can get it in the United States, but some of the arguments that we're raising can look quite a bit different. So again, in Europe, it's much more about articulating what the technical implementation choices are, the details, the technical benefits. Again, so those sorts of arguments are not always needed at the USPTO. It's much more about a discussion on what the invention is directed to. So again, it's maybe more of a style difference on, but the underlying invention typically, if it's eligible in one jurisdiction, it typically will be eligible in the other between the US and the EPO. So now looking at a few other countries. So again, we definitely do see a number of patent filings happening now in China, especially involving AI. So similar to the European approach, China employs a two-step test, looking for technical features and do these features form a technical solution. So again, but not necessarily tying that into the inventive step or obviousness determination. This is much more about actually applying this as an eligibility test, more similar to the USPTO. So we definitely do see that AI algorithms can be a technical if they're actually related to this technical problem being solved. So China seems to be increasingly receptive to a number of AI inventions and patent applications being eligible as long as it's tied to a concrete technical problem and has some technical output with the data. Um, so this could be things like sensor outputs, imaging data, physiological parameters. Again, if that data itself has some technical meaning, then rather than just abstract data, it does seem to be that those types of inventions in the medtech space can be eligible here. I did want to identify, in particular for AI inventions, there are some new examination guidelines that were recently released. In particular, the China Patent Office wants to ensure compliance with a number of national laws, and that they want especially any inventions that and claims and patent applications that use AI to not achieve a result that would be contrary to Chinese law. So, for example, patents can't be obtained on AI inventions that use some sort of discriminatory decision criteria or that they would say violate social morality or the public interest. Now, there's already been an existing prohibition on patenting inventions in China that contravene laws or morality or public interest, but now this is actually being directly considered for AI operations. So you really can't have the AI achieve a result that would be contrary to China law. So that is something perhaps that there may be certain types of medical outcomes and perhaps even medical treatments. Again, if they wouldn't be compliant with Chinese law, that maybe you couldn't rely on the AI, the use of AI to sort of overcome that. And additionally, certainly this presentation is much more about eligibility, but the latest AI examination guidelines do make it clear that there's going to be more requirements on providing a detailed disclosure on how the AI works, such as training processes, data relationships, whether the acquisition of the data itself could be lawful, how the model training is technical. So there may be more hurdles again in China for applicants to rather than just again treating the AI as a black box. There may be more details that are required there. So now looking quickly at some other Asia Pacific countries with kind of what is and isn't eligible with AI inventions. So Korea treats AI inventions much more like its other computer-related invention standards, so software-based inventions. Again, they hinge eligibility on whether the invention embodies technical ideas that utilize a law of nature. So if it involves a device, drives a technical process, if it implements something some technical information processing, that typically would be eligible. If the claim is more centered on judgment, human mental activity, that would be something that would be ineligible. In Japan, likewise, AI inventions are examined under software invention standards. Most inventions will qualify as technical ideas. A key requirement for software generally in Japan can be that what's happening, the information processing, especially that's being performed by AI, it must be concretely realized using computer hardware or a technical system and not using humans. And again, that may be more of a form changing the claim to make it clear that the computer is performing these operations rather than a human. So they're also looking at whether subject matter eligibility can be when the AI system solves a technical problem or produces a concrete technical effect. So again, this could be improving the device, improving performance, the use of specific hardware. So again, looking for those technical benefits, that would be more of a European type of factors. Um, you're unable to claim data algorithms or data processing in isolation. Um, Again, this is mathematical formulas, analysis, abstract ideas. But again, if as long as it's implemented in the computer software, it's probably far more likely to be eligible in Japan. Yeah, in Australia, so this is an interesting one because we see their patent office often will follow the rejections or the eligibility standards that are made for counterpart applications at the U.S. Patent Office. So if you're filing in the U.S. and Australia and prosecuting at roughly the same time, you will often see some of the rejections and some of the logic kind of follow Australia will follow what the U.S. PTO is doing. Now, they do have a different eligibility standard. They're looking at this idea of whether the invention has an artificially created state of affairs, so something that's not just natural, and whether that invention provides a technical contribution. So this was most recently discussed in a case a few months ago in the Aristocrat versus the Commissioner of Patents case. The Australian Patent Office attempted to appeal this decision to its High Court, which is the equivalent of the United States' Supreme Court, but this appeal was denied. So it does seem that, again, like the latest legal precedent seems to be in favor of patent eligibility, even for um, perhaps some more abstract type software ideas. But it really remains to be seen how the Australian Patent Office will refine its examination guidelines and kind of where the boundaries will and won't be for software and AI. And then now back to North America. Canada focuses on the idea of the actual invention. Again, looking at factors such as whether the claims have elements that solve a technical problem, looking at the concept of physicality. It doesn't seem though that the guidance on software and AI inventions, this continues to evolve. There was some guidance that was released last year, but then withdrawn. So again, it seems that certainly I can't pronounce what the current standard is as a U.S. practitioner for what Canada is doing right now. But again, it does seem like Canada is asking for more detailed disclosure of AI and more details on what that involves. What is a technical relationship? So, claims that again that are directed towards devices, towards something physical in medical, medical devices, physical data acquisition on patients themselves. Those things would probably more tied to physicality. So there would be probably more arguments in the favor of that. But again, there's certainly remains to be seen how AI inventions will play out in Canada. Okay, so I've tried to at least come up with a kind of a brief, quick, put it on the screen, some chart on how the different eligibility tests that we've kind of compared and contrasted. Again, as you can see, the USPTO has its multi-step test. But again, the US will often look at some of the same factors as other patent offices. We're seeing things about the technical features, technical effect, the technical contribution. We're often seeing those just being repeated. I also included just a quick column here to identify whether a country has AI-specific guidelines on how examiners and applicants are to treat AI claims that directly involve AI. And really, we do see all of the patent offices around the world now include some detailed guidance on AI. And in some cases, some of these guidelines are just more building on existing software based inventions. But oftentimes they actually go into more details, calling out specific use cases for AI and claims that are and are not compliant with AI.
With these different standards, can eligibility for AI inventions be achieved with a single uniform claim set or inventive concept?
Yeah, that's a good question. I mean, I think the I think it's maybe hard for a single claim set to be viewed as compliant in all of these jurisdictions. Again, because again, they're looking at some different things. Again, there's maybe different formats for how the claims are written, but maybe the common thread that we can see throughout all these jurisdictions is that a patent application that sets forth the technical effects, the technical solution, and what's being improved in the technical field. As long as those are apparent from the claims and are maybe even explained in the patent themselves, that's really what all of these patent offices are looking for. So again, this idea of technical and what's happening in the technology itself. So of course, this is a challenging to do in the medtech field, and when AI can often be considered as a black box. But maybe that's the best approach is to really look at technology as a solution. So I also did a quick comparison about claims that are directly uh, directly focused on medical treatment methods and medical diagnostic methods. So again, this is a sort of a comparison of the jurisdictions we just talked about. In summary, the US and Australia are most permissive on actually claiming a method of applying a medical treatment. So this would be something that actually would be infringed by a doctor, typically, or someone that's actually doing a medical treatment to a human. There is a prohibition for the medical treatment side of things in most countries. However, there's a large carve out because devices and systems themselves that implement a medical treatment are eligible. You just can't claim the method itself. Again, so the idea would be it's okay for a medical device to apply a medical treatment that's novel and unique, inventive, but you certainly wouldn't want in Europe, you wouldn't be able to get claims on a method of doing that and be able to sue a doctor for infringement. So it's often about recasting the invention as again, maybe the form of it on a device, a system, rather than the method itself. And I've also, included a column here to discuss methods of medical diagnosis. It's a pretty similar outcome. Again, viewing that as abstract uh, or whether some countries actually have a direct prohibition on the diagnosis of especially on a human. But again, there are a number of exceptions, especially if computer data processing, a device, a system is involved itself.
So is there a general principle that we can state for these jurisdictions?
Yes, I think one way to view this is that methods of medical treatment, if they involve a physical device or system, they are generally eligible really throughout the world. And again, this is something that we would see on medical devices, especially if they're whether or not they're using AI, and medical diagnosis methods that involve a physical device or system that are also generally eligible. But then differently written claims can obtain broader coverage in some of these countries. And so maybe that's maybe if there's a takeaway thing, it's that customizing claims for different jurisdictions can have benefits to get slightly broader or different coverage. Okay, so
Hey,
let's
Robert, before you,
Mhm.
we have a question from a
Yes.
listener. And I think this question came in when you were talking about uh, humans and abstract ideas.
hmm Yes.
So the question is not AI based on training on mental processes of humans? So I think the question relates to, well, isn't everything AI have to do with probably an abstract idea or a mental process?
Yeah. No, I think that's a good observation kind of at its core. Everything in AI would could be considered as abstract or even just as a mathematical operation. And so it really becomes a challenge of trying to cast the invention and not saying that the invention is doing something that it doesn't do, or but rather to focus on the technology. How does it actually work in the technology, in the computer, in the data processing space, and what are the effects that the technology can have?
And there's certain arguments like it's not practically able to be performed by the human mind and things like
Yes.
that that can be useful in the United States anyway, correct?
Yeah, yeah, absolutely. It's a good observation. Okay, so let's take a few moments to go back to the USPTO and kind of focus in on some of the more recent guidance here. So the USPTO has released guidance and a number of claim examples to help practitioners identify how Section 101 and subject matter eligibility is evaluated. For MedTech, one of the more interesting examples is Example 49 that was released in 2024. So this is a claim, like sort of a fictional claim directed towards the personalized treatment of glaucoma-related fibrosis using AI. Well, I'll show the claim here in the next slide. The main principle that the Patent Office seems to distinguish is that claims tied to generic outcomes, even if they're using AI, they may be ineligible, but claims that are tied to specific treatment steps are eligible. So let's take a look at the claim here. So walking through this hypothetical claim from example 49 on a fictional invention, again, we've got a first step of collecting genetic data, a second step of identifying a specific risk value by processing this genetic data in an AI model, and the third step of broadly administering an appropriate treatment. So presumably, if this fictional invention is new and non-obvious, it's because of how the AI data processing, really the step B, how that's being performed. We even have very specific details in the clause B of this claim that talks about how the AI model works and what it produces, how the model uses multiplication and the weights in certain aspects. But the USPTO concludes that the um, the details of this AI model, the specific mathematical operations and what the model is doing here, this is directed towards abstract ideas and a law of nature. So so again, I think that again this example has been criticized by a number of commentators on exactly what is the patent office looking for. Again, we have a lot of details about what the AI is doing, how the AI is working, but again, this claim is written in such a way that it really focuses on mathematical operations. um, rather than um, rather than how it's actually making the invention itself work better. However, the USPTO does find that there is really a carve out to these judicial exceptions when a treatment is involved. So this is based on applying a particular treatment of a medical condition. So they actually find that claim two here is eligible. So it's not just any treatment that, and not just applying any medical treatment generically, it actually needs to be a particular treatment. So even though AI and data processing is involved, it seems like the main factor in this example is whether there was a particular treatment to show a practical application of what's happening in step B with the use of this AI model here. So again, that's kind of a little bit of a convoluted way to reach the outcome. So um, again, if the point of novelty involves AI, really the question is should the eligibility of the claim rely on a downstream use of that, um, especially if it's applying uh, a very broad category of administering a treatment. So again, this has been criticized by a number of commentators. It's not really clear um, eh, at what point does the AI matter? If the AI matters for purposes of novelty and non-obviousness, then it's a little unclear why um, why the carve out for applying a medical treatment can be so broad. So again, just looking at this claim as a practitioner, I can see questions about divided infringement. Again, we're going to have multiple parties, one party collecting the data, another party processing the data, another party providing the AI model, another party providing actually administering the treatment. So again, this I wouldn't want to have to draft a claim in this fashion. Is it really even detectable? What's going on in a few of these steps here? Where is the point of novelty? Again, this is a fictional claim here, and really, is it truly enabled, and kind of what's going on in the AI model? So again, just because we have an example from the patent office that says here's what you could do, I don't know that this is really that much practical guidance beyond the fact of a particular treatment can make a difference. So, the other thing with recent patent office changes, examiners in a number of AI-heavy art units received a memo in August, really reminding them to consider some of the patent office's guidance and especially some other examples that involve training a neural network, example 39, and example 47, which talks about using a neural network for data processing. So really, both of these examples are really focused in on what the bounds of a practical application of data processing. What does that mean in the context of AI? So it definitely seems like at least the current USPTO um, does want to emphasize to examiners that when we're arguing about practical application, especially when applicants are providing evidence of practical application, that can be important to consider whether something is or isn't eligible.
So which technology centers was this guidance sent to?
Yes, so yeah, 2100, 2600, 3600. Those are communication and software art units, business method art units that typically will involve more computer processing of data. So maybe the point of this and bringing up in this presentation, this will have some effect, but maybe some limited effect on art units where MedTech inventions are classified. So I was a little curious, like looking at our 120,000 patents, how many of those are falling in these more software-based art centers and which are falling in other technology centers at the USPTO. And I came up with these statistics here. So most MedTech AI cases fall within 1600, which is biotechnology and organic chemistry, and 1700, which is chemical and materials engineering. And then really the remaining filings are spread out. We can see 2600, 2100, and a number of other art units. So perhaps this memorandum and the idea of AI processing, this will have some effect on on examiners that do MedTech AI inventions, but it's probably going to more affect traditional software examination settings. So also wanted to note that about 2 months ago, the USPTO provided a memo to all examiners about some revised guidance on a precedential appeal decision that reversed a rejection of a patent application for Section 101. So this precedential appeal decision was ex parte Desjardins, and the main holding was that claims directed towards training a machine learning model can be eligible if they improve the machine learning technology itself. So the particular invention that was being appealed involved, as I understand it, mitigating catastrophic forgetting in an AI model and enabling continual learning so that the model itself would be improved over time. So this seems like the USPTO was saying, well, if the patent applicant can show how the model improves itself, then that could be a factor for eligibility. So this does seem like a promising development for inventions that involve some improvement in AI and how the AI works. So if it's an improvement to the model architecture, maybe how that's being trained, how inference accuracy is being done differently because something is being reconfigured in the AI itself. That itself can be an improvement to a technical field, even if it's running on a conventional computer. And I have on the slide here just some of the language that's going to be added to the Patent Office Examination Manual, the MPEP. So this section, MPEP section 2106, is very long already. There's a long list of cases that discuss eligible and ineligible claims. So again, it's a little unclear how much effect this is going to have on individual examiners or on applicants, but it's definitely a good sign that we have another case that talks about how AI works. AI works itself. Again, they characterize this as improved way of training a machine learning model is eligible, an improvement to performance based on how the machine learning model is trained and is working. So it's a little unclear. Again, is this going to be persuasive or very particular to only certain cases and some uses of AI? And then another thing I'll highlight quickly is the Patent Office also released some guidance to examiners explaining that Rule 132 declarations can be used for subject matter eligibility arguments. So Rule 132 declarations, they're occasionally used by applicants to provide objective evidence of especially non-obviousness, such as industry evidence or expert evidence on why something isn't obvious under the prior art. They actually suggest here that these can be used for Section 101 rejections, especially whether there's some evidence that the invention can't be performed mentally, or that it improves the computer functionality, or that there's perhaps an unconventional treatment, or maybe just that there's a discussion between or disagreement between the examiner and the applicant on how one of ordinary skill would understand what is and isn't technical. So this could be a way in which we can maybe get a little more evidence, a little more arguments provided at the USPTO. So there's also a couple recent case law decisions that I'll quickly put up on the screen. I would definitely just say that the enforcement of patents that involve AI, again, we're getting some mixed guidance because some claims in these patents do broadly claim the use of AI. They are invalidated, but some of these patents that are being asserted are quite a bit are quite old. Number of them are more than 10 to 15 years old, and certainly would have been drafted when AI was treated. I think as maybe as a little bit more high level without actually getting into some of the details on what's going on, and maybe trying claims that we're trying to prophetically read on how AI works. So I got four cases that I'll maybe just put on the screen here real quick here. they involve some aspect of AI or medical processing. Um, Again, I would put the two cases on this screen kind of under the bucket that if it's just um, treating like data transformation or applying machine learning to new contexts, that won't be eligible. Just simply finding a new use case for AI isn't itself enough to make an invention technical and won't be eligible. Another case here, um, one that actually did find eligibility. Again, this is involved a weight selection system. It was actually a number of mechanical things that are happening as a result of AI processing. So that case was found eligible. Um, and again, the last one involving some use of AI was given a very it was just released a couple weeks ago. Yeah, that one was found ineligible. So again, there wasn't enough details on the AI to take it out of an abstract idea.
So are there any high-level takeaways from these decisions?
Yeah, so I mean, it seems that I would say both the Patent Office and the Federal Circuit and in courts, they're really emphasizing the need for explanation of how the invention solves a problem, not merely what the invention achieves. So I see a takeaway is even though the US we don't have a technical problem and a technical solution requirement. Again, examiners are looking at different things, but often if the technical problem and the technical solution can be articulated clearly and show an advance over the art, that's often dispositive. So it's yeah, I think the idea here is that this idea of tying technical problem, technical solution, if you can make a legitimate argument on what that is, and that's clear to an examiner or that's clear to a court, you're far more likely to reach an eligible patent. Okay, so in light of everything we've talked about here, trying to wrap up, yeah, what are some of the kind of strategies that you can consider using? Um, so I'll first talk about for patent drafting. Actually, I think this just sort of summarized what I was just talking about. We definitely would say that patent offices worldwide and in the USPTO, they want to see a discussion of what that technical problem, the technical solution, the technical effects, making that clear in the actual discussion of the invention itself, explaining the how of the AI, especially if AI is used to obtain some result or drive some outcome. The explanation of what that is and the technical effects can be very important. I also put on the screen the idea of considering using track one prioritized examination. Now, we do see just kind of with the very small sample cases that I've handled, there's some small improvement in an allowance rate when track one is applied, and there's often a willingness for examiners to negotiate more, especially when Section 101 rejection occurs or there's Section 112 questions about clarity. It's much more of a negotiation back and forth rather than just applying that. So I wouldn't necessarily say that it's a higher allowance rate, but it's maybe more collaborative, and that
Say,
can.
Robert, we have a question that kind of relates to that.
Mhm.
How suitable is PPH for prosecuting AI-related inventions in MedTech in the USPTO and other patent offices, taking into the account that claims could differ between the different jurisdictions?
Yeah. No, I think that's a good question. I would think that in anything that can help advance anything that one patent office does, again, it's not dispositive. It can be at least a decision point that that examiner can make. So I think one way to view that is to maybe use PPH to get it on the track, especially if it's favorable, and then to work out the details on some of the, again, maybe there's some changes that need to be made at individual patent offices. But I would definitely think that PPH, prioritized exam, can only help applicants, especially if one is finding it favorable. It's more likely that some of those same factors are going to be relevant elsewhere. Yeah, and then the point I put on the screen here is that some of the newer AI tools that we're seeing available in the marketplace to help vet claims for, not only for prior art, but also for eligibility to identify some of the keywords that are maybe problematic so again, appropriate use of AI could be a possible way in which some of those claims and patent applications, the specifications can be sort of hardened ahead of time to reduce the likelihood of rejection. And then for cases already, yeah, in patent prosecution, again, just keeping in mind some of the newest examiner guidance, the new MPEP sections, maybe Rule 132 declarations. I've used it one time before unsuccessfully, but again, this was a number of years ago. Um, and yeah, also is now a good time to maybe consider appealing cases that are borderline. Maybe we have a little bit more favorable appeal judge uh, factors and judges right now to appeal case as needed. I also noted the use of method claims. Again, maybe this is more USPTO specific, but maybe the conventional wisdom is that the use of method claims in software cases is a bad thing because it's probably more likely to be characterized as a human activity or just using a computer generically. Um, but maybe method claims are actually better because if I actually can show here's an actual treatment that's actually occurring at that. So maybe for some med tech inventions, method claims might actually make a difference to show the real world practical application. Yeah, and then again, finally, to kind of just summarize a few of the things that we've talked about here today. Again, we're seeing maybe some divergence between what examiners are doing versus what the USPTO guidance is. Um, we're also seeing maybe some divergence between the USPTO and the Federal Circuit. Again, the Federal Circuit is dealing with a number of cases that they're looking for a lot more details in the patents themselves, the how to, how does the AI actually work? And again, that's maybe harder to achieve in some of the older patents, but maybe for newer cases, as applicants are prosecuting newer cases and are drafting new cases, really just um, tying that improvement to the technical field and the technology might be very important. So I think really just trying to draft robust patent specifications, coming up with detailed and focused arguments, it's really more important than ever. And it definitely makes our job harder, but maybe it's more valuable as patent practitioners here. And then maybe the final thing I'll say is, yeah, maybe over time some of the subject matter eligibility concerns may fade, and maybe it's going to be more about prior art, especially as as more AI tools are finding prior art that are in the space. Maybe as more AI generated prior art becomes available and publishes, and as research expands, maybe this is going to be less of a concern over time. It sort of remains to be seen, but. I think applicants definitely do have a number of tools out there to work with the patent offices, and again to overcome the hurdles, hopefully. And so with that concludes our presentation here today. And yeah, we definitely do appreciate everyone's time. And Marv, yeah, do we have any questions?
Thank you, Robert, and thank you to all the listeners for joining today's session. We appreciate your interest and look forward to your questions and discussions. If you'd like to dive deeper into any topic, please reach out to us directly and we would be happy to discuss with you.